because there we have a sub-headline there, sharp views of poll laws change. And this has, really taken the country by storm as citizens are given a chance to debate on these proposed amendments. And so far we've seen NASA members of parliament boycotting this joint select parliamentary committee discussing these proposed laws, amendments to the law. What does this signal to, especially even for the electorate that voted for these, elected these members of parliament? It is their mandate to take part in these consultations. Do you think their reason is sufficient enough that Jubilee is seeking to legitimize election rigging?
Validly, there are those concerns. Well, granted, it is Parliament's mandate to legislate on issues that are of national concern to all citizens. And being that from the verdict of the Supreme Court, there were some certain issues which were pointed out that these really ought to be looked into. But when you look at the elections management infrastructure as it is right now, and even from the words of the chairperson of IBC, really they do not need new laws for them to successfully undertake that elections. That is on record, it has been said, because the architecture of results transmission and collection which they've put in place is in line with the current laws. Remember, the verdict of the Supreme Court was for the IBC to conduct a fresh presidential election in conformity with the Constitution and existing election laws. So really, that will point out if those laws were to be changed and if they were to affect substantially the processes involved and the architecture of transmitting results, then it will put IBC in a very difficult position.
But the interpretation of that, under the existing election laws has been in contention. Is it laws existing during the time of the judgment? It's a question we've been asking, without quite a clear answer. Or is it laws existing at the time of the election? Because if these amendments are passed today, they will essentially be the existing laws by the 26th of October. So in terms of interpretation, what role or what route do we take as a country?
As it is, the definition of existing laws, it's very simple. Those existing laws are laws as at that time of the judgment when it was delivered. That is on 1st of September. So essentially, it will mean IBC is mandated now to carry a fresh rerun of those elections as per the regulations and laws which existed as of 1st September. This year.
All right, but at the end of the day, Parliament still has, a right, a constitutional right to continue debating these laws. But let's take a look at some of the issues that NASA has a problem with. I mean, pretty much all of them, considering the timing. But the biggest one I believe NASA has a problem with is with regard to transmission, because Jubilee now seems to be watering down the electoral transmission and putting more weight on manual transmission of results. And there have been questions about whether that will create a disconnect or not, considering we are still using the KIEMS kits, for election transmission. And then the second one is with regard to the IBC chairperson, Wafula Chebukati's powers, saying they're also going to be watered down if we're going to reduce the criteria of whoever can replace the chairperson. But I did speak to Samuel Chepukonga yesterday, former chair of the Justice and Legal Affairs Committee, and he says Jubilee is only proposing that in the event the chairperson is not there. They're not saying the chairperson will not be there. So, if nothing happens, the chairperson will still conduct the election.
There have been those valid concerns, especially to do with the role and functions of the chairperson, even from the chairperson himself, who had warned that it will be unnecessary for Parliament to water down his duties. Granted, the IBC Act, as presently drafted, provides for certain situations where if the chairperson is not there, then whoever it is who is the vice chairperson can be able to step in. When you look at Section 209 of the Constitution, there are provisions whereby it states if there's any reference to a state officer who performs any function, then it also means whoever it is who is acting in that capacity can validly be said to be exercising those powers. So really, there will be no need for Parliament at this juncture to change those laws to make it possible not only for the vice chairperson but also any other member. The caution was, if it is a commission considered of 7 members and the quorum, business quorum, they're proposing to reduce it to 3 members, then it will give you a scenario whereby if 3 if there is differences between 3 and 4, then it will be very possible for that to escalate, in that you'll find 3 commissioners who are of one view will want to have their own way, and the 4 others will have to have their own way. So as it is, it will be unnecessary to emphasize on that. The chairperson is still in office, and the vice, should he not be there, then there are regulations which allow the vice chairperson to come and step in.
All right, but of course we've had international envoys weighing in on the same, saying it goes against international best practice to change the rules of the game so close, or even halfway through the game. But at the end of the day, even, because there is rules and procedures in passing a bill, even if this bill passes, will it be applicable by the 26th of October?
That is the intention, because the President has been very clear. Especially with regard, take one example, the issue of returning officers and presiding officer not signing forms.
Right.
They want to put it in as a straight offence in the Elections Offences Act. But when you look at that laws as currently provided for, there are offences which can be said to be committed by staff and officials of IBC. Non-signing of those forms, or signing forms which probably has errors, or refusing or altering, those are already provided for. There'll be no need for Parliament to again create another offence, yet the existing laws provides for that one. True, international best practice, especially on elections management, will say that when you legislate, the principle of legislation is to put in laws which will serve citizens for posterity. You do not legislate to serve an emergency or maybe a present interest unless it is an issue of very serious public interest. Like 2008, when we had the post-election crisis, that is when there was a need, because of stalemate, there was a need for Parliament then to pass constitutional amendment to put in place a coalition government. So unless there's a national crisis, legislation should be posterity, not for just specific situations.
Okay, so we'll take a look at more of that on The Nation, because this is